We'll resume the meeting. Please proceed, administration. Thank you. We're now at 55Y. Issue of ride-hailing vehicle driving permit. The commissioner may impose any licensing or permit conditions that the commissioner considers appropriate. Subdivision 2, cancellation, etc. of ride-hailing vehicle driving permits. Section 55 said, if the commissioner is satisfied that with the conditions A to E are met, the commissioner may cancel the permit, suspend the permit, or vary the permit. The specific factors for consideration includes a ride-hailing vehicle driving permit holder is convicted of an offense under the relevant sections, say soliciting passengers or conveying goods with the vehicle. A ride-hailing vehicle driving permit holder's full driving license to drive a private car or light goods vehicle is cancelled. A ride-hailing vehicle driving permit holder is disqualified from driving a taxi under this ordinance or the Taxi Driver Offence Points Ordinance. For any condition of a ride-hailing vehicle driving permit has not been or is not being complied with, or any other provision.
Next, Division 6 are miscellaneous. So these are miscellaneous provisions. First, 55ZA. So that's on page 33 of the marked up copy. Well, a ride-hailing service license must not be transferred without the approval of the commissioner, and also a ride-hailing vehicle permit or ride-hailing vehicle driving permit must not be transferred. So that's the first one. Mr. Sunny Tan. Thank you, Chairman. I might have omitted something. Well, it's about the car permit and also the driver's permit. So the validity period will be 3 and 5 years respectively. But then when it comes to cancellation, I did not find the part concerning renewal. Yes, thank you, Chairman. Thank you, Mr. Tan. Concerning the permit's validity period and also the renewal arrangement, those will be set out in the subsidiary legislation. Those would also be under 55Z(c). So when we come up with the regulation, these are the issues to be covered. Next, 55ZB. That's page 33 and 34 of the markup copy. Well, a person aggrieved by a specified decision may apply in writing to the commissioner for a review of the decision by the Transport Tribunal. The application must be made within 21 days beginning on the date on which the written notice is served. And then subsection 3 provides for the specified decision, including to refuse an application refuse an application by the licensee, and also to give a direction and to impose a financial penalty. Mr. Frankie Yik. Thank you, Chairman. I'd like to go back to 55ZA. Well, this morning, when we discussed this, we talk about whether the car permit has to go through an auction, and then there would also be cost. If there is a fair competition, then there should be a cost incurred. And then we were told that that would not be considered for the time being because they were concerned about speculation. But then if it's provided that there is no transfer allowed, so there is no question of speculation, and that need not be considered. Thank you. Yes, Bureau Director. I think we share the same view. That is, within the validity period, the permit cannot be transferred, and there is no question of permit speculation, and therefore, it would not be done via an auction. But then, according to Mr. Yik, you think that this is not going to happen anyway, and therefore that would not constitute our decision that it would not be issued by way of an auction. But then, in fact, we share the same common ground. Please move on. Well, we talk about 55ZB. The legal advisor's letter also asked that how come the specified decision does not cover the conditions to be imposed by the commissioner on the private car license. because that's to regulate the platform and also the operation as well as the driver to ensure that the service provided is up to standard, and also to ensure the safety of the passenger. And therefore, the company or the individual having the permit would also have to comply with the relevant conditions. And therefore, with regard to imposing of condition on the permit, that would not be covered by the specified decision. And the legal advisor also asked in his letter that if there is a need to provide for the procedures to be taken or to be followed by the tribunal, and also when the decision of the tribunal will come into effect, that will be provided for in the subsidiary legislation. And in terms of the power making or the regulation making powers, well, under B and C, well, the secretary will come up with the regulation, and then the transport tribunal will be able to review his decision. And also under Cap 374, the implementation details in regulating ride-hailing service platforms and so on. Well, we believe that the above provisions would already be sufficient in regulating the commissioner's decision and also his power to make regulation and so on. As to empowering the commissioner to come up with regulations and subsidiary legislation, the transport tribunal can also review the decision by the commissioner, including 7(1) and L and M, and also 7(1) and M. So there is no need to make reference to the procedures here. Next, 55 set C. The purpose is to regulate the ride-hailing service, and the technical details will be provided here. And then for the rest, that will be provided for in the next stage of subsidiary legislation, and the Secretary for Transport and Logistics can regulate on the platform and the drivers, and also the licensed platform can also provide public transport passenger service. And we can also use the subsidiary legislation to regulate that without limiting this. 55 set C 3 subsection 3 and 4, we can set out what the service can cover, including the validity of the license, and also the renewal arrangement, and also the license conditions, how that can be stored, and so on. So those can be provided for here. And also, as we said, 55 set C6 already says that the Transport Tribunal can review the decision of the Commissioner, and also any other matters for carrying into effect the provisions of the ordinance. And the legal advisor also said in his letter that the platform, the cars and the driver, if there is any damage, then 55 set C can also provide for the power to make regulation. In fact, 55 set C1 already set out that the Commissioner can make regulation concerning the service to be provided. We believe that this power is sufficient to cover the provision of original copy of the permits and so on. Next, 55 set D. This is about the fees, and subclause 1 and 1 is about the application for and the issue of ride-hailing service licenses, the fees, and also the renewal fees and so on. And then B, authorize the Commissioner to waive, exempt, reduce, or refund the whole or any part of such fees. And then subclause 2 and 3 provide that such fees can be set at different levels, and that can be set to recover the cost incurred. And legal advisor has also mentioned that if the fee is above the cost incurred, then what are the justification for that? As we said in the morning, the initial thinking is that concerning the service license, it would be set at a level higher than the cost incurred. As to the actual fees to be charged, that could be charged in accordance with the scale of operation of the platform and the number of car fleet, and also the number of drivers and so on. And the legal advisor also asked whether or not it's appropriate to include in the bill that a cap be set for the fee to be charged. And he has also given an example under the fire services legislation. In fact, with regard to the fee to be charged, we will be setting that out in the subsidiary legislation. But then for Cap 57219T may not be an appropriate reference, because it says that the SAR government can do this to specified persons. For example, with regard to fire safety improvement devices or measures, the cost incurred can also be recovered from the person, and therefore that sets out the cap or the limit to be charged. But then we believe that is very different from what we are setting here, and therefore Cap 572 may not be applicable here. Next, 55 set E. The Secretary may by regulation make related amendments to any enactment as are necessary consequent on the enactment of the Road Traffic Amendment Ride-Hailing Service Ordinance 2025. That would be confined to the amendments related to this bill, and that would also cover Part 3's amendments. They are very similar. Please move on. Next. Clause 9. That's page 39 of the marked up copy. Page C3951 of the English version of the Blue Bill. That's to amend section 69. Well, if somebody has been convicted of an offense under this ordinance, his license will be cancelled for a certain period of time. Under 69(1)(a), that's to distinguish between offences committed for driving an ordinary car and also under this bill, and that is for illegally offering the ride-hailing service without a license. And also with one capital letter A and one capital letter B, it provides that the person will be disqualified for a period for no less than 12 months, but not more than 3 years. And the magistrate can also order for a shorter period of cancellation under certain circumstances. Well, another technical amendment is to amend 69B2 or 692B so that it would apply to the cancellation of the driving permit. So if the court decides to cancel somebody's driving permit, then at the same time, his ride-hailing vehicle driving permit will also be cancelled. Next is clause 10. So that's on page C3955 of the Blue Bill. That's to amend section 88B. The Commissioner, in granting an application for ride-hailing vehicle permit, he can request that the private car has to be tested for roadworthiness to ensure that the car is roadworthy. So that car will have to be tested at the car testing center. Clause 11, that's on page 42 and 43 of the marked up copy. That's on page C3955. That's to amend section 1021I. So the reference of the ride-hailing vehicle, so that pre-service training can be provided to the service providers. Next is there are 5 parts to the related amendments in Part 3. One is to amend Dangerous Goods Control Regulation Cap 295 Subsidiary Legislation G. So that's to amend Section 81 so that for any person on public transport carrier, he must not carry any Part 1 dangerous goods, and then the ride-hailing vehicle would also be part of that, and therefore public service vehicle within the meaning of this would also be covered, so that would also be treated as a public transport carrier. Division 2, that's to amend Waste Disposal Ordinance Cap 354. Under Section 16A2, if waste is disposed of by a vehicle, then under Section 16A1, that would be an offense for any unlawful depositing of waste, and therefore corresponding amendment would also have to be made so that ride-hailing vehicles would also be covered. Next, Division 3. That's to amend Smoking Public Health Ordinance, Cap 371, and that would cover clauses 14 and 15 of the bill. And those are to amend Cap 371 under Section 4. Nobody would be permitted to smoke on a public transport. And therefore, in Section 2C2, that there is already a definition of that. And therefore, we propose that under public transport carriers, ride-hailing vehicle would be covered, and details would also be provided in that section.
Mr. Kong, I have a brief question. I note that for the new 4A, item 4A, it says a ride-hailing vehicle that is in the course of providing ride-hailing passenger transport service. That is, I'm guessing, beginning when a booking is accepted. Why is it that we do not have the same standards adopted for taxis, but only for ride-hailing vehicles? So at other times, one may be able to smoke. Is that the case, say, when they're waiting? Mr. Cook, yep. Ride-hailing vehicles are differentiated because at other times they are private cars. It is only when they are providing such the relevant service that they will be seen as a public transport carrier. So even if a passenger is not being conveyed, if they are providing such service, the vehicle will be seen as a public transport carrier. Thank you. Mr. Frankie Yik, I'm not sure how we're going to tackle this issue. Some passengers dislike this odor of cigarettes. How can you make sure that drivers won't be smoking in their vehicles, causing odor in the ride-hailing vehicles? Commissioner, well, we often see smoking of drivers rather than passengers, and we have been educating taxi drivers and passengers to make sure taxi drivers won't be smoking in taxis. Mr. Cook, yep. In future, in taxis, we have in-car cameras that will be filming the taxi drivers, and if passengers smell odor of cigarettes in taxis, they may lodge a complaint. Thank you. Please proceed. Division 4, Chapter 375, Road Traffic Driving Offense Points Ordinance. We are amending Section 8 to add a reference to ride-hailing vehicle driving permit. If one is disqualified, the ride-hailing vehicle driving permit is seen to be invalid while one is disqualified from driving. Sorry, I have another question on smoking. So this becomes effective when they have accepted a booking. So if I accept an order the night before and I will only convey the passenger the day after, is it the case that one cannot smoke in between that time? Mr. Cook, yep. I think in general platforms assign bookings shortly before a booking is to be served. So if you're talking about orders being placed the night before, I will see if we'll need to have other arrangements to cover that scenario. Mr. Sunny Tan, I have a follow-up question. We have seen before when we're in other jurisdictions, if we want to book a car to get to the airport, we will make a booking the night before. So I think it's less than occasional that we'll see this happen. Please consider this. Thank you. Ms. Joyce Cock, please proceed. Thank you. Division 5, Entertainment Special Effects General Regulation, Chapter 560A. This clause amends Section 26. It is only with the approval of specific officers that pyrotechnic special effects materials can be conveyed in public vehicles. We suggest including ride-hailing vehicles as one of the public service vehicles. Mr. Gary Jiang, yes. I note that with the amending of Section 26, the category is public service vehicles. But then for smoking, the smoking provision, Clause 15 use or Clause 14 as well, you would say specifically a ride-hailing vehicle is in the course of providing ride-hailing passenger transport service. Why is there such differentiation? Ms. Joyce Cock, I want to explain the definitions. So we have in Section 2C2, Chapter 374 being referred to in Clause 15. And we are defining a ride-hailing vehicle in the course of providing ride-hailing passenger transport service to be a public transport carrier. It may seem to the member that there are different definitions because in different provisions there are already some explanations. Maybe, for example, in smoking public health ordinance, they will already have some other descriptions. In general, they mean the same thing. Are you done with the clause-by-clause examination? Yes, we're done with the clause-by-clause examination. Alright, the Bills Committee completed the clause-by-clause examination. I would like to ask Mr. Frankie Yik and other members if you have any committee stage amendments to propose. Perhaps Mr. Frankie Yik can speak first. I would first like to thank members for giving me the chance to ask many questions today. The taxi trade was against ride-hailing services, but based on the latest trends, they now accept this is what is going to happen, but they want to have a level playing field. They want to have fair competition. So I have three main concerns on the regulatory framework: the fare, the loophole, and the vehicle age. I believe for the loophole, the administration will be trying to plug the loophole. For fare, the administration does not have any plans to impose a schedule of fees, and they will only intervene when something happens. The taxi trade is pessimistic. I don't think you will intervene at all. As for vehicle age, as I said earlier, ride-hailing vehicles would only need $50 per day for their costs, whereas for taxis it's $500 per day. Let me give you an example. In Shanghai, they do not require other registration requirements. They have an age threshold of 8 years. In Shenzhen, it's also 8 years. In London, they have a limit of 5 years, and they can operate the vehicle until the vehicle is 10 years old. So you can see the requirements are quite different from what we have in the regulatory framework. So I will propose a committee stage amendment to lower the age limit so that there will be fair competition, because we need to ensure proper survival chances for taxi trade. When can you submit the relevant amendment? I can submit the proposed amendment tomorrow. Are there any other members who would like to speak? Chair, I would like to say something. I would like to circulate my proposed amendment among members. If members support this, I hope that the Bills Committee can propose this amendment. If not, I'll propose the amendments myself. All right, administration, would you propose any committee stage amendments? Thank you, Chair. I would first like to address members' concerns with the committee stage amendments. First of all, about detention of vehicles. We strive to have the draft amendments submitted tomorrow. There will be quite a number of amendments. We do want to submit them as early as possible to the Secretariat for circulation among members, and we can discuss the amendments at the meeting on Monday. I would also like to thank members for their great preparations beforehand. They have asked many valid questions. We have in general addressed the questions. We do know that some points are worth exploring further, and we will see if it can be dealt with in subsidiary legislation or with amendments to the existing bill. If there are other technical amendments, we will also submit them tomorrow. Thank you, Chair. If the draft amendments can be submitted soon, I will set the deadline for submitting amendments to be this Sunday, 21st of September, so that we can discuss the proposed amendments on Monday. Anything else we have to discuss today? If not, the next meeting will be held between 3 p.m. and 6 p.m. next Monday. We'll discuss draft amendments. And if you have not clarified some points, please submit a written response, administration, so it is better for members to draw reference from on the administration stance. There being no other business, meeting adjourned. Thank you.